Good afternoon, everybody. My name is Marcus Gehring, and I'm the director of the Center for European Legal Studies. It's my great pleasure to welcome you all to this afternoon's rapid response seminar on the proposed UK Northern Ireland Protocol bill. The two research centers, the Center for Public Law and the CELS, have teamed up to host this rapid response seminar. So, and there will be ample time for you to ask any questions that you might have. Please use the Q&A button to ask your questions. Our first three speakers are Professor Laurent Bartels, who's Professor of International Law and Fellow of Trinity Hall here at the University of Cambridge. He was recently awarded an OBE for his services to international trade law. Our second speaker is Professor Catherine Barnard. She's the Professor of European Law and Labor Law. She's a Fellow of Trinity College, Cambridge, and also one of the directors of UK in a Changing Europe, an initiative that analyzes the position of the United Kingdom in post-Brexit times. Our third speaker on this first panel is Dr. Stefan Theil. Dr. Theil is the legal fellow in Sydney Sussex College and teaches international and EU law and public law at the Faculty of Law. Welcome to this first panel, and without any further ado, I hand over to Professor Bartels.
Thanks, Marcus, and hello, everybody. So I'm going to outline a little bit what has just happened on the UK side and say a few words about what the UK is concerned about. Well, as you no doubt know, otherwise you probably wouldn't have tuned in, there's been quite a bit of action recently with the Secretary of State, Liz Truss, saying that the government was going to introduce legislation that would override the Northern Ireland Protocol because the Northern Ireland Protocol is not working. And of course, that negotiations between the UK and the EU are not helping fast enough to solve the problems which the UK sees in the protocol's operation. So let me just say a few quick words about what these problems are from the UK side. As you'll know, as probably everybody knows, the protocol is primarily, in its controversial aspects, about a border, and in particular an external EU border, which isn't between Ireland and Northern Ireland, but is rather between Northern Ireland and Great Britain. And the border does two main things. It allows for the in fact, requires the imposition of EU customs duties on products going into Northern Ireland, either from Great Britain or from other countries. And secondly, it applies regulatory rules, customs controls rules on certain regulations, which correspond to the more important aspects of the internal market. And all of that is necessary so there doesn't have to be a border to check on these things on the island itself. Now, as far as the customs duties are concerned, there is a carve-out. EU customs duties don't need to be applied to products that are not at risk of leaving Northern Ireland and going to Ireland, all of which seems sensible. But that's about as far as the protocol goes, and it still allows for a pretty rigid set of checks for products going from Great Britain to Northern Ireland, which is, of course, a problem for those in Northern Ireland who are used to buying things from, or were used to buying things from Great Britain without too many checks. The cost of these checks is enormous. The manufacturing industry in Northern Ireland has estimated around £200 million a year for this. A lot of suppliers have simply given up doing this. So this is, culturally speaking, aside from economically, culturally speaking, people in Northern Ireland aren't able to buy as much from Great Britain as they used to. Economically, a lot of this gap is being then supplied from Ireland. So what does the government want to do about this that isn't being done through negotiation? I should say there have been a number of unilateral waivers, grace periods, and so on, which go further than the protocol would allow to ease these imports. Essentially, what the government wants to do is to say, look, we've got an at-risk regime, which talks about when products are going to stay in Northern Ireland. We want that to be much more generous in its presumption, so that we assume the products that go into Northern Ireland are going to stay in Northern Ireland unless there is a good reason for them to move on to Ireland. So that itself is a change in the presumption. There are technical ways that this is described. Secondly, it wants the same regime for regulations as for customs duties. At the moment, there's no at-risk mechanism for regulations, not formally speaking. There are these unilateral concessions and decisions and so on, which have that effect. But the government says, no, what we want effectively is a green channel, it calls it, for products, both for customs duties and for regulations, for products that come from Great Britain and are likely to stay in Northern Ireland. That goes further than the protocol's system. And there are a couple of domestic issues as well. The government says, well, at the moment, subsidies law, EU subsidies law applies to any subsidy, not only in Northern Ireland, but in Great Britain as well, that could affect trade with the EU. And the UK says, well, we've got a new subsidies law, and that should take account of that. So we don't need that EU regime anymore. And there's another point which the government is making about VAT, which at the moment in Northern Ireland, VAT is within the EU system. And the government says, no, we want that to be the UK system. And that's essentially a question of the extent to which there will be an undermining of the EU's financial interests. There is finally a question, a governance question about the European Court of Justice, or Court of Justice of the European Union, to give it its proper name, which the government doesn't much like and wants to get rid of and say we should deal with disputes through an arbitral mechanism. But I think that's going to be discussed at some length later on, so I won't say any more about that. So this is a sort of snapshot of where we are with this legislation that is to override apparently to override the Northern Ireland Protocol. And I won't say anything, despite being an international lawyer, about domestic legislation purporting to override international law. There's plenty to be said by others later on that point. Thank you.
Thank you very much, Laurent. Thank you, Professor Bartels. I'm handing over to Professor Barnard, who has a PowerPoint for us.
Okay, thanks very much. So thank you, Lauren, for setting the scene. I'm being asked to look at the potential remedies or actions that the EU could take if the government does what Lauren has just described, to introduce legislation to override parts of the Northern Ireland Protocol. So essentially, there are three strands to what I'm going to say. I'm going to say a little bit about Article 16. I'm going to say a little bit about the withdrawal agreement dispute resolution mechanism, and then I'm going to say a little bit about the dispute resolution possibilities under the TCA and the actions that can be taken under the TCA. Article 16 I'll start with, and we've heard endless amounts about Article 16, so I don't want to dwell on it apart from to flag up a couple of issues with it. So Article 16 is a safeguard clause. And the first point to note is it says if the application of this protocol leads to serious economic, societal or environmental difficulties. Now, what's striking is although there was much talk about Article 16 last year, end of last year, it seemed to have died away, but then hints of it re-emerged in the last couple of weeks when we hear about concerns about societal difficulties and indeed trade diversion. Now, the key point is to note that it does look like there's a causal link that is required if the application of this protocol leads to these difficulties. The interesting question then is, could you justify using Article 16 to remove the role of the European Court of Justice, given that the European Court of Justice has so far had no say over the operation of the withdrawal agreement? The point about diversion of trade is a complicated one too, because the whole point about one country or part of a country staying in a customs union is that there will inevitably be diversion of trade. That is what a customs union is about. And of course, Northern Ireland has a foot in both the EU's customs union and the UK customs union. The other point I want to draw to your attention from Article 16.1 is the second sentence. And this is that any measures taken under Article 16 are restricted in their scope and duration to what is strictly necessary. And so the way I try to describe this is it's intended as a surgical strike. It is not intended as a basis for totally rewriting the whole protocol. And then third sentence, priority should be given to measures which will least disturb the functioning of the protocol. So there's been much discussion as to what Article 16 means. Probably the best article on it is by Rob Howes, who tries to explain that Article 16 is sui generis, it's something very special. But I think most people agree that because of the language about restricted in scope and duration, it is not intended to be a general renegotiation clause. Yes, it is possible to renegotiate the treaty and renegotiate the Northern Ireland Protocol. Article 13.8 envisages that, but it is renegotiation which is bilateral, not unilateral, contrary to some of the observations made by Ian Duncan Smith and others. If we were to engage Article 16, but in a way that is outside the scope of Article 16, then it seems to me that the dispute resolution mechanism in the withdrawal agreement itself, which I'll talk about in a moment, will apply, as will the general EU remedies, which are enabled by Article 12 of the Northern Ireland Protocol. The other point to remember too is that if the UK does legitimately or perhaps illegitimately invoke Article 16.1, the EU can respond with safeguard measures, and the safeguard measures that it takes must be proportionate. The other point to note too is that there is a long process. I won't go through all the details, it's summarized for you on the slide, but to note that if the UK is considering taking these safeguard measures, it's got to give a month's notification, then there's a period of consultation, and then there's a 3-monthly review. And this is part of a general approach that you find in trade law, that there is a strong push to try and get things resolved politically before you go down the route of sanctions, tariffs, call them what you like. Now, if the UK government decides not to invoke Article 16 because of the legal constraints in Article 16, and the UK government just says, well, in fact, we are going to suspend what's likely to be Articles 5 to 10 and 12 of the Northern Ireland Protocol, or indeed turn off Articles 5, 7 to 10 of the Northern Ireland Protocol, then what other things can be done? Well, first and foremost, the EU might start proceedings under Article 258. Those are the general enforcement proceedings that we know from when we were members of the EU. The EU had already started enforcement proceedings because the UK unilaterally extended the grace periods that Lauren had mentioned, and then suspended them in the hope that talks might resolve some of the difficulties. It may be that the EU promptly reinstates those proceedings or starts new proceedings in respect of the more significant breaches proposed in the legislation. I'm not going to say any more about that because that's pretty familiar territory, apart from to remind the audience that under Article 258, there is no damages or penalties imposed straight away. There's got to be 2 iterations before a financial penalty can be imposed on the defence state, in this case, the UK. Another possibility is that there might be a challenge by an individual or a company in the courts in Northern Ireland. Article 4 says that the withdrawal agreement has direct effect and supremacy over conflicting UK law. But of course, then that raises the interesting question about conduit pipes. And if the conduit pipe is the Withdrawal Agreement Act of 2020, amending the 2018 Act, which expressly is to repeal the provisions giving effect to Article 4, that sounds rather convoluted, then it may well be that that action is declared inadmissible in the domestic court. So most likely we are talking about the Withdrawal Agreement Dispute Resolution Mechanism. Now, the Withdrawal Agreement Dispute Resolution Mechanism looks like this. It's got a political stage where the matters go to the Joint Committee. That's the committee currently chaired by Liz Truss and Sefcovic. And if the political stage doesn't deliver, it can go to an arbitration panel. And then the UK has a period of time to comply. And assuming we don't comply, then you get into temporary remedies. Now, temporary remedies is a misleading term because temporary they probably are not. And this can be a lump sum or penalty payment, or if not, it could lead to suspension of parts of the withdrawal agreement, but not part 2 on citizens' rights, or any other agreement which takes us into the trade and cooperation agreement. So you can have suspension of part of that. So that would mean tariffs being imposed. So it is pretty serious once you get down the line. It may be that the UK government is hoping that all of this will take significant amounts of time, a year, so something can be negotiated or resolved politically in that time. Now, the other thing that's just worth bearing in mind is that the EU has a whole bunch of other ammunition in its armory that it could use against the UK. Now, the UK takes comfort from the fact that when Liz Truss made the announcement, the EU did not go in all guns blazing. My understanding is that they are taking a fairly gentle approach, but they are prepared to escalate. And the most dramatic escalation that they could take is Article 779, which is terminate the whole of the TCA. There's no reason needs to be given. They've got to just give 12 months notice. And that does require unanimous agreement by the EU. Perhaps less dramatic, but still pretty serious, would be to terminate the trade part of the TCA under Article 521, only 9 months notice there. 772, I think, is least relevant here because sorry, 772 is a possibility, but perhaps may not be used, although it does allow for suspension of the TCA if there is a serious and substantial breach of the rule of law. But if there is a serious and substantial breach of the rule of law, why use 772 when there is already a dispute resolution mechanism built into the withdrawal agreement? So perhaps that's least not relevant. 773 is another safeguard clause, so overlaps with Article 16, so less relevant. It may be that the EU looks elsewhere, looks at continuing problems with fisheries and starts action in that regard. And there, it's short and sweet. They just got to give 7 days notice before they start retaliating. And finally, what we're already seeing at the moment is lack of cooperation in respective areas where the UK would like to be involved. For example, there is no access for the UK to associate membership of Horizon. And I am hearing that it's very likely that any potential membership or associate membership of Horizon is literally disappearing over the horizon. This is not going to happen. Maybe that the French decide to become much more rigorous in their customs controls is another possibility. The final point I want to make, this is my last slide, is this. This is a document which, to my shame, I had totally missed when it first came out. But it seems to me to be directly relevant to everything we've been talking about. It's a proposal for a regulation which gives the European Commission the powers to take action through implementing measures in respect of breach of any of the provisions that we've been talking about. So if you can look over here, look, there's Article 16. It gives the Commission the power to act in response of the, under Article 16. You've got all of the other provisions that we have mentioned. Look, there's 749 there. So the Commission can act by implementing measures. You don't need to go to the Council to get permission. Once this regulation is adopted, the Commission will have power to act. So it is all ready to go on the EU side. The question is how they're going to use those powers. Thank you very much.
Thank you very much, Catherine. It is this was such a clear explanation that we can go without further ado to Dr. Tile's presentation on the EU and the member states' reactions to this announcement from last week. Stefan.
Great, thank you so much, Marcus. I'll keep it short and sweet. Essentially, the responses from various member states have been variations of the word no. Now, there are some nuances that we can pick out, and I'll try to convey that with a couple of examples. So the German Chancellor has recently said that nobody should violate or unilaterally nullify the rules that we have jointly agreed. The Belgian Prime Minister agreed with that in substance. Spain's Foreign Minister has urged the UK to implement the protocol in full and to avoid any unilateral moves that would put the agreement in jeopardy. You may have heard also that a US delegation was recently in town and reminded the UK government that in their view, unilateral action on the Northern Ireland Protocol will not work, and has insisted that the UK abide by this, mostly from the perspective of the Good Friday Agreement and providing stability for Northern Ireland. Poland, perhaps a bit more conciliatory in its tone, it is warned of a damaging EU and UK trade war, especially against the backdrop of the war in Ukraine, and has called on both sides to compromise. But again, if that is the high watermark of support for the UK position, I do not think it would be very satisfying from the perspective of the UK government. I think the overarching issue, which has been noted by the media reports and in other circumstances, that the EU has so far refused essentially to reopen any negotiations on the protocol itself, even instead offering a package of measures that may ensure a more smoother trading arrangement with Northern Ireland, but otherwise urging the UK to return to the negotiating table and to cease and desist from any unhelpful unilateral actions. So I think the overarching sense here is that there's more talk of escalation than there is of resolution these days. Many of the concerns, I think, on the EU side have been around trust and goodwill of the UK government. There's simply just not the sense in there that the UK government is acting in good faith. And even though some of the issues that Laurent has raised by the UK government are seen as legitimate concerns, there's currently just not the scope or the goodwill on the part of the EU to lead these to an easy resolution, because there is a sense that the UK government may not be acting completely in good faith. One example that's trotted out a lot is that a recent EU change, unilateral change, from the perspective of the EU anyway, there was a major concession in terms of medicines just back in April, and instead of that inducing the UK government to be more cooperative, it is instead led, from the perspective of the EU anyway, to the UK government being more emboldened to seek even further concessions on the Northern Ireland Protocol. So the announcement of draft legislation, I think in summary, is seen as hostile and is counterproductive. At best, it's a negotiating tactic. At worst, it is a ticking time bomb, given the considerable lag that would be between the introduction of the bill and the receiving of royal assent to any bill. And I think I'll leave it there in the terms of the overview of the reactions. Thank you.
Thank you very much. I would propose that we go to the rest of the presentations now, and then tackle any of the questions in the Q&A. Stefan, you will take over the next part. Thank you.
Great. Thank you so much, Marcus, and thank you for handing over the baton, so to speak. I'm briefly going to introduce both of you. So Marcus Gehring is, of course, the director of the Center for European Legal Studies here. He's also a fellow of Hughes Hall and directors of study there, and a fellow of the Lauterpacht Center. Marcus is going to give us a bit of background on what the member states might do from the legal perspective. Marcus, over to you.
Thank you very much. I'm going to briefly talk about unilateral actions in EU and international law. And just to remind everyone of the legal position inside the European Union. Unilateral acts by member states are severely curtailed by the duty of loyal cooperation. We have leading case law by the Court of Justice, starting with the Mox Bland case, but then also the PFOS case and the OIV cases, where the court explained that the duty of loyal cooperation with regards to international law means that even for international agreements to which the EU is not a party, but where an international standard could have an impact on the autonomy of the EU legal order, member states are barred from acting unilaterally without consulting their colleagues in the Council or working with the European Commission. So unilateral acts are not exactly favored by the European Union legal order, and I would expect if the Court of Justice of the European Union ever got involved in the proposed Northern Ireland Bill as outlined by the Foreign Secretary, it would probably see some of these and transfer some of the hostility to unilateral action also in their interpretation of the rules. Now, when it comes to the Northern Ireland Protocol in international law more broadly, Professor Bartels alluded to the fact that, of course, it is true to all students of international law that your domestic legal order cannot change your international legal obligations. As such, there needs to be an international reason to, for example, withdraw from an international treaty. The withdrawal agreement was, I should highlight, negotiated without a withdrawal clause. It was requested by the UK to include a withdrawal provision, but in the negotiation, this proved to be one of the red lines for the European Union. The withdrawal agreement, by its very nature, is also not one of those international agreements that should allow easy withdrawal. Now, the Northern Ireland and Ireland Protocol is an integral part of the withdrawal agreement, but does have a quite sophisticated withdrawal clause that Professor Barnett alluded to. Article 13.8 of the protocol said that any subsequent agreement between the Union and the United Kingdom shall indicate the part of this protocol which it supersedes. So in a way, you can amend, you can suspend the entire Northern Ireland Protocol by adopting an international agreement that supersedes one of the provisions or several of the provisions of the Northern Ireland Protocol. In my view, that largely precludes any other form of withdrawal from that particular protocol. Now, there is a provision on democratic consent in the Northern Ireland Protocol, which allows the democratic institutions in Northern Ireland to withdraw from the single market provisions. So that's Article 5 to 10. The participation, the continued participation of Northern Ireland in the single market is subject to this Article 18 of the protocol. Essentially, from the 1st of January 2025, and subject to a 2-year transition period, the Northern Ireland democratic institutions could decide no longer to participate in the single market of the EU. But that is strictly subject to a bipartisan support. So it's very difficult, in my view, to see how the nationalists designated assembly members would agree to the suspension of the participation in the single market. I should also highlight, and maybe that's just a normal part here, that in my view, the Trade and Cooperation Agreement, the TCA, does not contain any explicit provisions superseding the protocol, and a sort of more textual analysis, therefore, of Article 13.8 would indicate that no part of the TCA supersedes as in and by itself the Northern Ireland Protocol. Just to highlight, there is reference to international obligations. For example, the EU and the member states have WTO obligations, and we've seen the first WTO dispute being launched in March of this year on subsidies for offshore renewable energy projects where the EU is suspecting that subsidies provisions are not complied with. So that to me also indicates that it's not going to be easy to find a consensual bilateral solution to some of the state aid subsidies provisions that the UK is proposing to suspend. I would like to end on quite a striking provision that I think not very many people have realized, and I think any interpretation by the Court of Justice would take very seriously. Article 4 of the withdrawal agreement talks about methods and principles relating to the effect, the implementation, and the application of the withdrawal agreement itself, and by extension via Article 182, also to the Northern Ireland Protocol. And it says the following, and students of EU law will recognize the language. The provisions of this agreement and the provisions of union law made applicable by the agreement shall produce in respect of and in the United Kingdom the same effects as those which they produce within the Union and its member state. Accordingly, legal or natural persons shall in particular be able to rely directly on the provisions contained or referred to in this agreement, which meets the conditions for direct effect under union law. The United Kingdom shall ensure compliance with this paragraph, including as regards the required powers of its judicial and administrative authorities to disapply inconsistent and incompatible domestic provisions through domestic primary legislation. So we have domestic primary legislation, and there is a question for our constitutional expert how we can possibly sort of adopt a bill that undermines Article 4 of the withdrawal agreement. And that concludes my short presentation. Thank you, Stefan.
Thank you so much, Marcus. That was very insightful. I'll now pass over to Alison. Alison Young is the Sir David Williams Professor of Public Law and researches in all aspects of public law, most notably for our purposes today, UK constitution law. She's also a fellow of Robinson College. Alison, I'll hand over to you.
Thank you, Stefan. I wish I had an easy answer to Marcus's question. The standard easy answer is we have parliamentary sovereignty. And this is also sort of trotted out as the standard answer to any question as to why the UK Parliament thinks it can do what it wants to do. In particular, we've seen this more recently with regards to the ability to legislate, to empower the executive to act contrary to international law, specifically the Northern Ireland Protocol. And what I want to do is explain a little bit about how this works in practice, maybe giving us some insight into some of the problems that this gives rise to, both with regard to how the UK Constitution operates and also with regard to how this means the UK government tends to enter into negotiations. Now, we see the UK as having parliamentary sovereignty, and we see this as meaning that the UK Parliament can domestically, as an aspect of domestic law, do whatever it wishes to do in terms of subject matter. And this is wheeled out to suggest that much as there may well be these international law restrictions, that's a matter of international law. What we're looking at within the UK Parliament is a matter of domestic law. And so we can domestically do this. It's not a problem. And if there are international consequences, then it's for international law to sort those out, not necessarily restricting what we can do domestically. And that is pretty much how it is understood. And I want to suggest that it is a little bit too simplistic to look at it in those terms. First, the reason why it can be simplistic to think about it in these terms is maybe in the centenary of Dicey's sad or not so sad, depending on where you come from, demise, we need to revisit what parliamentary sovereignty is there for and why he justified having parliamentary sovereignty. And for Dicey, this meant that we didn't need legal limits because we could rely on political constraints. So it's a bit like saying, just because you can do something doesn't mean you should. And there should be political mechanisms of restraining what you can do. Well, what are these political mechanisms? Well, first we can look at the political mechanisms that are meant to impose restrictions on ministers. And this is where we turn to provisions of the Ministerial Code. Now, within the Ministerial Code, there is a provision requiring that ministers uphold the rule of law and uphold law. Now, this used to be including international law, and there was an argument when the Ministerial Code was changed as to whether it was still meant to include upholding international law. Following this change, this was resolved in a discussion in the courts, a case called the Gulf Centre for Human Rights and the Prime Minister, where it was agreed that it would still include international law. And that is something that if you talk to ministers in government, they will tell you, yes, it's still meant to include international law. So the idea is, yes, you can do this, but you're politically constrained because you're not supposed to do this as a minister. But then the question becomes, well, who enforces the Ministerial Code? Well, the person in charge of enforcing the Ministerial Code is the Prime Minister. And this is where you begin to understand some of the problems of unraveling this. Because do you look at this as this is a self-restraint? And if it is a self-restraint, can you argue, well, it doesn't apply in situations of emergency or when there's good, strong political will to suggest there's no need for this restraint in these particular circumstances? And then you can argue that perhaps there's a justification for acting in this way. And these are the kinds of arguments that will get put as to why it might be possible, even though you have these provisions of the Ministerial Code, to nevertheless act to empower individuals, to ministers, to either act contrary to international law or unilaterally modify international law. Yes, there'll be consequences on the international stage, but if the consequences in the UK stage are just political fallout, and you think they're worth the political fallout, then that won't necessarily be a huge element of restraint. Another element of potential political control is you are having to rely on legal officers, including civil servants, to give advice as to whether it would be lawful or unlawful to act in particular ways. Now, the civil servants are also governed by the Civil Service Code, which also includes an element of ensuring that you are not acting contrary to international law. And this can place the legal officers and also any kind of legal advice that is sent through to these legal officers in a very kind of awkward position and situation. Are you in those particular positions where, as a civil servant, you might feel, as Sir Jonathan Jones did with regard to the UK Internal Market Bill provisions, that you're being put in an impossible position, and in a sense you then need to resign because you feel that almost you're being asked to advise or support a proposition that would ask you to breach international law. Now, this is obviously very tricky because it's putting a lot of responsibility on civil servants, And it also calls into question how far we should be able to look at legal advice to hold governmental ministers to account. Legal advice needs to be kept confidential to ensure those giving the advice to the government can do so freely, fairly, giving a full array of these particular positions. And it's then up to the government acting on that legal advice to decide what policy choice it wants to make on the basis of this. But that, of course, then makes it very problematic to hold individuals to account when we're put in these difficult situations. Another further complicating element was raised by Marcus with regard to, well, what about the withdrawal agreement? And what about the fact that this gives an element of requirement that we have to give direct effect and primacy to the Northern Ireland Protocol? Well, this is provided for in the European Union Withdrawal Agreement Act 2018, and you have similar wording to the wording you found in the old European Communities Act. This is the idea of having legislation needing to be read and given effect subject to these provisions of the withdrawal agreement, but still retain and still have sovereignty, which of course includes the Northern Ireland Protocol, which then creates yet another dilemma of what do you do if you have legislation that clearly says we're acting contrary to the Northern Ireland Protocol and earlier legislation saying we're not supposed to do this. How can you read and give effect to this in line with the primacy of the Northern Ireland Protocol if legislation clearly states it's contrary to the Northern Ireland Protocol? And all I can say is, I hope I'm not the judge having to decide that, because there's not a clear legal answer as to how we would respond to this. So what are the deeper consequences? I think what it shows is when we're dealing with the UK Constitution, we're used to this idea of political rather than legal constraints. And this seeps in not just to elements of being able to perhaps propose law that domestically might be okay, but internationally might not be, but also it seeps into how we approach negotiations. We're used to a situation where we can politically negotiate because we're not used to a situation with clear backed legal controls. And I think this leads to a lot of misunderstanding when we're discussing the aspects of negotiations between the UK and the EU, because the EU is an institution that has clear legal limits on its powers, which I'm afraid means that it's putting us in a very difficult clash when it comes to trying to negotiate a solution going further. So I'm afraid all I can do is raise problems. I wish I could provide solutions, but I'm not that good. Thank you very much.
Thank you so much, Alison. That was great. I'm going to hand over the master of ceremony duties to Catherine, who's going to take us through the questions, the Q&A.
Well, thank you very much indeed, all of you, for those terrific insights. I appreciate Alison's honesty that she doesn't have all of the answers. Clearly, Suella Braverman has had answers, and that's why she's got legal advice. And we're told that it is going to, a summary of it's going to be published, and we shall wait for that with bated breath. May I urge you all to put your questions in? I can see that there are 4 already in the box, and I will sort of try and pull them together where they do overlap. The first question I would like to raise is from Keti Getachew, who asked the question, essentially, how robust is the UK's subsidy regime? And is it legitimate to run the argument that Laurent said on behalf of the government, not he's acting on behalf of the government, but he said this is what the government would argue, that having got our own subsidy control regime, we don't need to have the EU regime anymore. Laurent, I don't know if you want to answer that, or have you got any thoughts on that, on the robustness of the UK regime?
Yeah, I mean, the UK's regime is pretty strong, actually. I mean, there's an interesting thing about the EU's initial asks on subsidy. We speak generally, which is the EU's take was always that the UK is exiting as a member state, but it should continue to be treated as a member state for purposes of subsidies effectively, which is a bit odd because the UK said, and I think there's some, from an international law point of view, some justice to this, that the UK is now at the same level as the EU, and the EU does not subject itself to any subsidies regime. That subsidies regime only applies to its constituent units, namely the member states. So to begin with, there is an asymmetry. What would be symmetrical is for the UK to have a subsidies regime that applied to its constituent units, the devolved administration. So that's as background. Now, given all of that, it is surprising, I mean, maybe not wholly surprising, but let's say notable at least, that the UK has a strict subsidies regime that in most respects is similar to the EU's regime, in some respects actually stricter in terms of thresholds. But where it differs significantly is that there's no requirement to obtain ex-ante approval of a subsidy, subsidizing or want to be subsidizing. Authorities need to ask for a non-binding opinion, which they are then free to disregard, and enforcement is all ex post facto. Now, whether that's important or not, who knows? But I think that the UK, I think, has a strong case to say, look, we've done basically the same sort of thing. Yes, it's true that we are talking about subsidies mainly about Northern Ireland and Northern Irish trade with the EU effectively, but you know, we're pretty close, and the Article 10 of the protocol should be superseded. I think there is a lot of merit in that, but it's not there in the protocol, and so it would require a rewrite essentially. So yes, it might be that.
And just on, and Lauren, just to follow up on that, you said you had interesting views on, as a public international lawyer, about the legitimacy of the UK doing what Liz Truss is proposing. Do you want to summarise your views in a couple of minutes?
Oh, I think Marcus said it. I mean, from an international law point of view, you can't use your domestic law to override your international law obligations. The term for that is breach. It's pretty straightforward, pretty fundamental. Whatever you might think of the merits of international law in any given case, just saying that you don't care because of some constitutional reason doesn't really matter. I'm intrigued to see what the legal advice reportedly by an international lawyer says on that. Can't wait to see the summary.
Is there a concept of primordiality? This is, for those of you who've not been familiar with this term, I certainly wasn't until recently, that some agreements are primordial and thus trump other agreements.
In a very limited sense, nothing that's relevant here. So there's one primordial rule in international law, and that is called jus cogens in Latin, or peremptory norms of international law in English. And that is limited to conduct like genocide, for instance, or apartheid. So it's the really nasty stuff. Other than that, you can do whatever you like in international law. It's completely voluntary. What there is, which I think much is going to be made of in this, or has been made of in the legal advice, and we'll see what has been made of it in the summary, I guess, is a conflict of treaties concept. So, you know, an earlier treaty can normally be overridden by a subsequent treaty, provided it's got the same parties, or at least as between the parties that are the same parties, which you don't actually have a match with here. So there's one issue. There's that you know, override doesn't really even work. But what you could say, and here you also need the match of parties, which you don't have, is what's in Latin a lex specialis, or a special law, which is to say that the earlier treaty is not primordial, but it specifically regulates a situation to such an extent that a later treaty is to be considered more general and not to have regulated it, and therefore it doesn't really matter all that much. Well, I don't think that anyone could say that the Northern Ireland, well, some people can evidently, but so I better not say that, but let's just say it's not straightforward, that the Northern Ireland Protocol is less detailed and more general than the Good Friday Agreement. Most people haven't read the Good Friday Agreement, I should say. If you do read it, it's pretty much on the back of a postcard type stuff. It doesn't talk about the border at all. If any of these two treaties is general, it's that one. So the vibe of the Good Friday Agreement is obviously, you know, peace and harmony and so on. But then you could say the same thing about the vibe of the Northern Ireland Protocol. So you know, matching these two, let's say the most generous that I can say is it's by no means a straightforward case that the Good Friday Agreement should override the Northern Ireland Protocol and thereby be the basis for the international law basis for domestic law that purports to give it effect.
Thank you. That's really very helpful. Marcus, obviously you did a fantastic job explaining the international law position. Do you want to say anything about primordiality?
No, I read somewhere there seems to be an opinion that any treaty that's concluded with an international organization is not on the same level as a treaty with another country. So this sort of very creative form of legal interpretation would then say, though the Good Friday Agreement has Ireland as a party with the United Kingdom, so it's an international treaty, whereas the Withdrawal Agreement, the Protocol, the TCA are treaties just with an international organization and therefore not on the same level as international obligations vis-a-vis sovereign state. In my view, that argument has no veracity whatsoever in international law. It is true the Vienna Convention on the Law of Treaties does not directly apply to treaties with international organizations, but the most important rules all apply to treaties with international organizations as part of customary international law. So just to highlight that there are quite spurious and I dare I say very creative legal commentary out there, but it is just that. It is quite out there.
Yes, it's remarkable how many people have become experts in public international law, having become experts in COVID and all other matters at the same time. There's another question from David Erdos this time. Northern Ireland Protocol seems to be a unique part of the Brexit agreement. Even from the EU's perspective, it engages the EU and EU27 as a whole, but in a very special way. But one member state, namely Ireland, is, do you think, taking a distinctive approach to the issues which arise? And if so, do you think that approach has and is exerting special influence? So bottom line is Ireland in a special position? And if so, how? Does anyone want to volunteer to answer that? Otherwise, I'll just ask. Stefan, did you want to say something?
No, I didn't really want to jump the queue or anything. I think I don't have very strong thoughts about that. The only thing I would say is that, yes, of course, this issue affects Ireland in a special way, because ultimately the border will either run through the island of Ireland or it will run through the Irish Sea. So one way or another, I think there's the significant geographical proximity, I think, is beginning to take its toll there. But then again, I think these were things that must have been obvious to anyone at any point during the Brexit negotiations, and most importantly to a government that was very much willing to sign up to the quote unquote oven-ready deal that was the agreement in the Northern Ireland Protocol. So it's good that we're now wiser, or that the penny is beginning to drop more widely, but I don't think that obviously changes the fact that you have made certain commitments already, and that needs to be taken into account. So yeah. Thank
you. Does anyone else have anything to add? Marcus, go ahead.
Yeah, just to underline that the existence of the draft regulation that you highlighted, Catherine, seems to indicate that the Commission would act quite decisively. So then there's no need to go back to the Council or decide with any kind of majority what the next steps have to be. But I think Dr. Erdos is quite right. Several of the member states have underlined their solidarity with Ireland, and so I wouldn't put it past some of the member states, for example France, to then take measures in their bilateral relationship with the UK that could be quite detrimental, in addition to any kind of EU measures that might be taken.
Thank you. We're coming up to the end of our session, but I did want to just ask the question that Jonathan Little has put, which I think is rather pertinent, which is essentially, are there any incentives for the EU to make further concessions to the UK, who can then promptly bank them and say those are still not good enough because still the Good Friday Agreement's being affected, and therefore they just sit on their hands because they feel that the concessions that they were prepared to make in October have been described by the UK government as going backwards rather than forwards. In other words, what would you do if you were the EU? I know you're not rushing to answer this. So Marcus, you can say something, and then Laurent.
Yeah, I mean, Commissioner Šefčovič, I thought put it quite decisively, saying that the overall arching objective is to find joint solution within the framework of the protocol, but that the UK would not hesitate, the EU would not hesitate to act decisively if the UK really sort of advances this piece of unilateral legislation. I agree. It's I don't know where this form of negotiation comes from. I find it quite disturbing that a government that is such a strong supporter of multilateralism basically resorts to sort of a mini form of blackmail in their relationships with the EU, but then maybe there are broader constitutional questions that I don't see from my point of view.
Thank you. Laurent, what would you do?
Well, I think there are two types of negotiations that you can have that are relevant here. So one is where the issues are de-linked, that what one side wants is de-linked from what the other side wants. And the other is where they're conditional. So let's take a conditional one where the EU might say, in fact, this is what's being discussed, that we will allow, easier access for goods coming into Northern Ireland based on commercial data as opposed to filling in customs forms, right? So data that's already there. But that, of course, depends upon the EU getting its hands on that data. And if it doesn't, then what the EU has conceded is undermined. So clearly, where you have conditional, a proper reciprocity of concessions, they both need to be maintained. And then if the UK said, well, thanks very much, we'll bank that, but then we won't give you the data, then there's an asymmetry. But I think that's very different from when you have a negotiation which is based on what either side might be able to give up. And any element of reciprocity is de-linked from that. And really, I don't think that's an appropriate model because both sides have the same interest here. And that interest is peace and stability in Northern Ireland. So the EU should really be doing whatever it can to achieve that. And the UK should be doing, as little as it can to disrupt the workings of the protocol and to protect the EU internal market as it can. So they really should have the same overall interest there. And I'm not sure that, if we had the situation referred to here in the question, which is the UK banks a concession. Well, if the EU were able to make that concession in the first place, good. Then it can afford to give that concession. The UK should be able to bank it. I don't think that there needs to be any particular negotiation. We'll do that only if you do something else. So I think it's a different type of negotiation in most respects, but not in all. There can also be conditional issues linked where I think banking would be a bad thing. Well,
thank you all. Our time is up. I want to thank very warmly all of our speakers, Laurent, Alison, Stefan, Marcus, and Marcus in particular for pulling all of this together. Thanks as always to the law faculty, in particular Dan Bates, for keeping the entire show on the road. I'm told that there may be legislation on the 6th of June, so we haven't got long to wait. And maybe we'll be forced to do another seminar then when we actually know what we're talking about, and we might have seen the summary of the legal advice by then. Thank you all, as always, for following us, and thank you to our audience for your questions and for your support. Thank you and goodbye.
Thank you.